Hi, I'm Dave Dinkle, and welcome to our video series of actual recent deals. This is a deal that netted the student $21,623 with no money in the deal. The following is an actual real estate transaction that was recently completed, in this case by a student, and it exemplifies some of the various aspects of how we do these transactions. So as not to embarrass anyone involved in this transaction, all parties have been kept anonymous. I'm not a CPA, attorney, or realtor. Any information derived or found in this presentation is not to be construed as legal or accounting advice. This is an example of an A to B and B to C double closing where the investor used the end buyer's money to actually fund the deal. The original seller was a probate who sold it to the investor is B, and the investor sold it to another investor who ultimately was a rehabber. But the important part is there was no money in the deal. None was needed as the end buyer, who turned out to be the rehabber, funded the A to B transaction. There was no credit. There was no conventional lender involved, so the investor didn't have to borrow the money, and there was no risk because the investor had no money in the deal. When I say no money in the deal, you're going to see in this transaction once again, there's no earnest money deposit on the original A to B transaction. So this is a good example of what appears to be an impossible deal because it's a probate that also needed a short sale to make it work. In addition to that, it happens to have been a reverse mortgage. So actually the property, because it was in probate, was bought from the personal representative. In probates, in most cases, what happens is the judge has to approve the sale, and the reason for that is so it's not a sweetheart deal where it's sold well below market value to somebody that's part of the estate and trying to avoid either estate taxes or liabilities to other creditors because this is a personal residence. The property was solicitor found from a family member of the deceased who felt very strongly that because it was upside down, more money was owed on the mortgage than was the value of the property. He felt that what difference did it make? It doesn't make any difference to the deceased person about his credit being ruined because the property is in foreclosure. They've delivered a list penance and they're going to go ahead and foreclose. However, this is one of the most overlooked parts of real estate investing because it sounds impossible. Here you have a probate that no one's in control of or cares about, so to speak, and you have a property that's going to go back to the reverse mortgage lender. Again, a reverse mortgage is very simply where a lender comes in and says to the homeowner, you have equity, and to be able to take that equity out, we will give you a reverse mortgage. Instead of making a monthly payment, the borrower, in this case, actually gets a check a month until such time as he's deceased. This meant, in the case of this particular reverse mortgage, the mortgagor had died and the mortgage had to be paid off or the lender would foreclose. The lender was a smaller private lender looking at a foreclosure action and its cost to do that and decided to look at a short sale. The lender accepted the short sale, and it only took about 2 to 3 weeks because of the requirement by the lender. And this is true in most reverse mortgage cases. All they care about is a death certificate to show that the borrower is deceased and a court order showing that the personal representative has been approved as the personal rep of the estate and to conduct business on behalf of the estate. So here's the first HUD statement. Again, this is the A to B, side 1. There's the purchase price. This is the student's purchase price, $205,390. Same thing with the seller. Again, the seller in this case is the estate. Closing cost for the investor buyers, $529. We'll see those on page 2. The seller has $23,000 worth of expenses, and we're going to look at those again on page 2 to see why it was so much. It doesn't matter. In the short sale, the bottom line is the seller should receive no money. What I said to you before about the earnest money deposit is happening right now. Here is where the earnest money deposit would normally be. As you can see, there is no earnest money deposit. If you're listening to this and you're an investor or a realtor, you're saying to yourself, it can't be. Well, here's the HUD statement, and there it is. It's a function of how you handle this as to how it actually happens or not. And the examples I've given you up to this time, I would say a third or at least 40% have had no earnest money deposit as the investor buyer on the A to B side. Why? The seller is motivated. He doesn't care about earnest money deposit. The only person that cares about that really is a person that's selling that's concerned with price. Generally, he's not motivated. Or a real estate agent who hopes that you don't close and he can make the money. Here's the payoff of the loan. It's $179,000 and change. Now we're going to see that the total amount due was higher, but they accepted this amount because we did a net sheet and we actually sent them in an appraisal also. So here's accrued taxes from the beginning of the year. Remember, for the investor, the buyer, this is a credit, and it's a debit to the seller on the other side. So here's the bottom line. The student needed $203,451.95 to close on the property, and the seller walked away with nothing. That's exactly how a short sale is supposed to work. Why would they even bother to uncomplicate the estate in this case because of it going into foreclosure? And they didn't have anything to do with it. They had very little work on their part. Otherwise, the homeowner has to fill out a financial statement. The purpose of the financial statement, frankly, is to show the bank where the seller's assets are, so if they come after him later with a judgment, a deficiency judgment, they know where to go directly, what bank he deals with, what account numbers he has, and so on. The other reason, of course, for the homeowner is a hardship letter, which is interesting, but he may not have a hardship. In this case, it's an estate. What's the hardship? At any rate, this is page 2, and what we're going to see is the seller's expense of $23,000. We're going to see where that money evaporated to. Here's again the investor buyer. His settlement cost to close is $415. Now, this is important. Remember, the seller, although it's the personal rep of the estate, this HUD statement has to be approved by the lender, in this case the reverse mortgage lender. When you start this process of the short sale, the lender wants to see what he calls a net sheet or preliminary HUD statement. The way you do that is you overload the fees and expenses on the seller side over here, overload these so that in fact you're not paying those expenses when it comes down to the actual closing. Here's one of the ways to do that. $415 for the settlement fee, but it's $1,295 for the seller. This money comes directly out of the lender's pocket, so to speak, because he isn't going to receive that at the end. He received his payoff, but he's not receiving anything in addition to the payoff, and neither is the homeowner. And if you notice, these costs just go on, and they're all placed, frankly, on the side of the seller. There's the abstract fee, $695, which is expensive for us. Attorney's fees, $1,250. Okay, now here's an important one. There was a probate attorney involved, and the only asset in the estate happened to be this property. So if this property wasn't sold, he wouldn't make any money for the time he spent. His original bill was like $1,200 or $1,400. However, look what he did here. He submitted a $5,600 bill at the last minute, which luckily went on to the seller's side because it had to resolve the probate. But that's a chunk of change, and he just took advantage of the situation. I know attorneys don't do that. This one did. Doc stamps and so on all shifted to the seller's side of the lien search. So the bottom line here is the seller paid $23,823.60 in closing costs, and this is the investor buyer side, and these are just incidental fees. His total cost was $529.50. So now he has the property, and if your question is did the $203,000 he owed come from? Came from the end buyer. The end buyer allowed him to use his money. Undoubtedly, some of you guys who are listening, your hair is going to stand on end, and you're going to say, you can't do that. Well, you're wrong. I don't care if you're an attorney. I don't care if you're the Supreme Court Justice of the United States. You're wrong, because as long as the end buyer is a cash buyer, agrees to it in writing, and it's disclosed to both parties, there's nothing wrong with it. It's a cash transaction. It doesn't fall under any of the guidelines for lending, which is where the federal issues come in, or state issues. If you do it right, it's not illegal. So here's the sale price. Now again, we've now switched. The end buyer is on the left, and he paid $230,000. Seller, of course, the student received the $230 as a credit. End buyer paid $1,715 in closing costs, and he put up a $10,000 deposit. I've said to you so many times, put up as little as possible, get as much as possible. In the event he didn't close, the student in this case would have made $10,000 on the deal because he didn't close. Larger deposit on the back end. Closing cost in this case for the student, seller, $2,400 and change. Again, here's the accrued taxes. These are property taxes year to date, and they're the same numbers as we saw on the previous HUD because they're both done on the same day. A to B side above, A being the original seller, B being the investor, are done just a couple minutes or an hour apart. The end buyer here, C, is the end buyer, and the seller, B, is the investor. All I've done is change the colors of these for you. So here we are. The end buyer had to bring in the closing $219,247 and change because he had a credit, a deposit credit, and he got credit for taxes whereas the student netted $226,074.95. However, it wasn't all his money. Remember I said to you that the end buyer financed the property? So what he actually received was the difference between what the end buyer had originally loaned him of $203,000 and the $220 and change, and you'll see that in a moment. So here's the HUD-1 closing statement, the B to C side. This is the second page. We're going to look at the expenses. There's a $395 processing fee, which probably had something to do with the realtor from the other side or something. I'm not even sure what that is. This is the settlement cost, $450, both sides. Abstract or title search, $200. The end buyer wanted title insurance, which is the correct thing to do, so he paid for it, $1,226 it looks like. The seller paid for the doc stamps, the student on the transfer, and these are just miscellaneous charges. Bottom line, the end buyer paid $1,716 it looks like, and the student paid $2,467. Now these closing costs vary greatly between closing agent, counties, and states. In New York State, for example, I believe there's a law that says only attorneys can do real estate closings, and these closing costs on average are about 3 to 4 times higher. Just because you see these doesn't mean that's what you should be paying. If you're going to be closing with a closing agent that you like and you trust, and he covers your butt, frankly, don't shortchange him by saying, you know, I always pay $450 someplace else, you charge me $500. You nickel and dime him to death, he's probably going to forget to tell you something in the future, or just say to you, you're not worth it. There comes a point in life where it's not worth it to win just to make a few extra bucks. Give him what he deserves. Otherwise, what's going to happen is you're going to get it in the end. The final result of this entire transaction. The final result of this transaction, when all was said and done, it was actually a complicated deal involving a probate that was upside down, so a short sale had to be done, and it had a reverse mortgage instead of a typical mortgage. Now, here's what's interesting. The lender originally wanted $237,000 as a payoff, but finally settled, as you saw, for less than $180,000. There was no transactional funding charge or other funding cost because the end buyer did the funding. He didn't charge anything for it. The student's net profit on this no out-of-pocket money deal was $21,623.00. Big coincidence. But again, he used the end buyer's money to close the A to B leg. The seller side of the A to B closing was originally done with approval of the preliminary HUD that only showed the seller's side, meaning the seller's expenses. And that's the way a preliminary HUD or net sheet should be sent to the lender. Don't show him what the cost of you as the investor buyer is going to be. All he cares about is the right side of the equation anyway. Put all the expenses on there you can get away with, increase the expenses. In that way, what's going to happen is he won't be looking at you and saying, well, you should be paying this, you should be paying that. Get it in that way. You can always adjust it later. That made a huge difference in the bottom line on this profit in this deal. Well, thanks for joining me. I look forward to seeing you on our next video series of recent deals.